Swayam Prabha. Digital India. Educated India.
Over the past few days, we had received some comments on the forum. Some of you have been active on the forum asking certain questions, and others have been active answering some of those questions which others have raised. I have seen certain questions which I thought I should bring to your attention. Rohit Singh had asked, what is the meaning of 39 of 1970? So if you see the Patents Act 1970, the title, it is followed by a statement in parenthesis within brackets 39 of 1970. This simply means it is the 39th Act passed by the Parliament in the year 1970. So it is actually Act 39 of 1970. All the acts that are passed by the Parliament in a particular year are numbered sequentially. So Act 1 of 1970, Act 2 of 1970. The Patents Act which was passed was the 39th Act that was passed in that particular year. Kirti Deshmukh has asked about the color coded act and the rules. That's still under preparation. When something is ready, we will let you know where it is available. Pallav Prince had asked a question which requires a more detailed answer, probably when we do the lessons on inventive step and novelty and patentability. Probably this question will get addressed. Now the question is, let's suppose a black pen is already patented by someone. We modified that pen and developed new product, have the same appearance, but that is a blue pen. Then can we make the patent for a new blue ink pen? This is a very simple scenario. As we know now that for patentability there are three conditions have to be satisfied. The invention has to manifest itself in a process or a product, and the three conditions being: 1, it has to be new or it should involve novelty; 2, the invention should involve an inventive step which is regarded as something that is not obvious to a person skilled in the art; and 3, it should have utility or it should be capable of industrial application. Now was this obvious to a person skilled in the art? That is a question we could immediately ask. The fact that there are existing black ink pen and with the same appearance you now make a blue ink pen. Now that would give us the answer. But in a normal case, understanding patentability will involve applying the three tests of patentability to the invention and also understanding the background art. So in a particular field, say if there was a real problem in developing a particular variation or an improvement to an existing invention, then that could qualify for a separate invention in itself. So modifications and variations and improvements are also inventions. So we will not dismiss them as saying that they are trivial. That is not the yardstick that the patent office takes. Rather, they will see whether that modification, variation or improvement was capable of satisfying the criteria of patentability, that is novelty, inventive step and industrial application independently. Shruti S had asked a question which is not covered by our syllabus. She had asked as the Plant Variety Protection Act 1970, correction, it is not 1970, it is 2001, protects asexually reproduced plants. Why is tuber producing plants exempted from this act? And 2, can vulnerable species be patented? Plant varieties, in India we have a separate regime for the protection of plant varieties. Some countries under the World Trade Organization have patents granted for plants too. So countries have an option of having a separate regime, a sui generis regime, which means a separate regime or an independent regime in itself for protecting plant varieties, or countries could adapt and modify their existing patent regime for granting protection for plant varieties. In India, we have chosen the path of having a separate legislation. So you will find more information on that in the website www.plantauthority.gov.in. P. Bharati had raised a question, why every country requires separate patent? Why don't we have a world level patent? Is there any possibility of filing for the same invention in 2 different countries? Is there any differences in benefits to a patentee from every country? Now countries, the way in which patent law has evolved, the patent law has evolved locally, in the sense that they were geographically specific. The laws of one country, just like any other law, the law of contracts, or the law with regard to buying and selling property, the law with regard to transactions, the law with regard to incorporation of companies, we don't have a global law. Similarly, patent law is also geographically specific, pertaining to the territorial limits of a particular country. In India, if a patent is granted, granting a patent alone does not solve everything. In fact, patents have to be enforced, and the enforcement mechanism happens in the courts of law. So, granting a patent in itself is not an end. Patents survive for a 20-year life from the date of application, and during this time patents need to be enforced, and enforced means if there is an act of infringement committed by a third party, the patentee should use the legal machinery to stop that infringement. So, enforcement happens in the courts, and courts, as we all know, are bound by the jurisdictional limits within which they operate. So, in India, the courts in India can enforce a patent that is granted by the patent office in India. Similarly, a patent that is granted in Sri Lanka can be enforced by the Sri Lankan courts, it cannot be enforced in India. This is how all the laws have developed, not just patent law. So, laws are specific to the territory in which they have application. The reason why we do not have a world level patent is that we still do not have a world level incorporation of companies, and we do not have a world level recognition of a property owned by one person in another country. In fact, even a contract that is signed between two parties becomes hard to enforce it in another country, unless that country is able to bring in some kind of a jurisdiction for looking into that contract. So, why we do not have is, there has been efforts to harmonize the patent laws of different countries, but we still have not reached the point where we can have a global cooperation on granting and enforcing patents. Is there a possibility of filing patents for the same invention in different countries? Yes, we have two mechanisms which we will be covering in the course of our lectures. One is by filing a convention application, by which you can file an application in one country and pick it up for prosecution in another country, or you could follow the Patent Cooperation Treaty route, the PCT route. These are two mechanisms or international arrangements for filing patent applications in different countries. Are there any differences in benefits to the patentee from every country? Patents are exclusive rights granted over inventions. All countries grant these rights. Enforcements in some countries could be much more effective, and based on the technology and the market, granting patents in certain countries could have a benefit to the person who wants those patents. So, otherwise the terms are the same, the rights that conferred by the patent are the same, but they are territorially specific. Again, to emphasize, what is granted in India cannot be enforced across the border, say in Bangladesh or in Sri Lanka. I should make a special mention about Mr. Pankaj Kumar. He has been very active on the forum, and he has been answering others' queries too. We are watching all the answers, so if there is an intervention that has to come from our side, we will certainly do that. Thank you.